lawsuits are settled through negotiation. What follows is the negotiation of a medical malpractice claim by two experienced lawyers who chose to have their clients present for parts of the negotiation. Commentators have identified two different approaches to negotiation: adversarial and problem solving. In adversarial negotiation, the parties seek to divide up a fixed resource such as money or land. What one gains, the other must lose. They tend to focus on positions, that is, specific demands or offers. Common adversarial techniques include an initial demand that is far removed from what the negotiator expects, limited disclosure of information about facts and one's own preferences, an apparent commitment to positions during the negotiation process, and the exchange of arguments and counterarguments. Many of these techniques are designed to mislead the opponent as to your true situation and positions, and to cause the opponent to lose confidence in his or her case. In problem-solving negotiation, on the other hand, the goal is to find solutions that benefit both parties, a result that sometimes is called win-win. To seek such outcomes, the negotiators concentrate on the parties' underlying interests rather than their positions. A position is a specific demand or offer. An interest is the need that lies behind the position. In the negotiation of a personal injury claim, for instance, the plaintiff's position might be a demand for $50,000, but to some extent this demand might be a stand-in for underlying interests such as needs for health care or transportation or for a feeling of rectitude. Problem-solving negotiation is marked by an emphasis on the underlying interests of the parties instead of their positions. That is, what they really need rather than what they initially say they want. This involves disclosing information that an adversarial negotiator might keep secret. And the negotiators will attempt to create options that promote the mutual gain of all the parties. For example, a person suing for money damages might plan to use some of the money to satisfy a particular need, such as a need for transportation. The defendant may be able to arrange such a service at a lower cost than the plaintiff could. So both sides could benefit if they made transportation an element of the settlement. In most good negotiations, there are elements of both approaches, and the two approaches often are in conflict with each other. The following scenes from a negotiation will illustrate some of the points I have just made. The plaintiff in this medical malpractice claim is Mavis Thompson, a jazz pianist. Her complaint alleges that the defendant physician, Dr. Miriam Decker, caused numbness in her hand by injecting it with a drug called AR-21. The complaint claims that Dr. Decker was negligent in choosing to administer the drug and in failing to obtain the patient's informed consent. The failure to obtain informed consent also is the basis for a battery count in the complaint. The complaint asks for damages as follows: $20,000 in medical expenses, $60,000 for lost income, $420,000 for pain and suffering, for a total of $500,000 in actual damages. The complaint also asked for $500,000 in punitive damages. The plaintiff's lawyer is James Bartimus, and the defendant's lawyer is Larry McMullen. The meeting takes place in Mr. McMullen's office. The lawyers have already agreed to treat all statements made in these negotiations as confidential. The first segment shows the beginning of an adversarial negotiation over just one issue, the amount of the settlement.
Jim, I appreciate your coming to my office this morning, but as I say, Jim, I really don't know very much about the case, except that it does seem to me that it's a case of very doubtful liability. And I'd like to know your views on it, and I'd like to know what your expectations are for this case.
Sure. Larry, as you know, this case just got referred to me, too. I've been through it, had a chance to read the depositions. I brought the medical records from her subsequent treatments after the injection by Dr. Decker. I brought some x-rays I can show you. I've been through the petition, and I'm bothered by a couple of things, as you well know, and I think that they perhaps can set a bad negotiating posture. First thing I want to do is drop the punitive damage claim. You know, I don't believe in that unless it's there. I don't think in this instance it's there. I briefly mentioned it to Mavis. I told her I don't think there was any conscious disregard by Dr. Decker. So we'll drop the punitive. That's out of it. Second thing is it's not a battery case. And as you well know, I think there's a consent problem here. And I also think, although it wasn't pled, and I can always voluntarily dismiss and refile the case with my pleadings, I'm hopeful maybe we can get this resolved in light of the insurance question here. But I see it as a theory on negligent treatment in that Dr. Decker gave her this AR-21, and I think you may be familiar with this with other cases, but it's a water-soluble synthetic, and gave her this injection the first time this lady shows up. No history that she's a jazz pianist. And the background is the lady was getting ready to do some performances. She developed some pain in her hand. As a layman, she thought it might be early arthritis. She goes in and sees Dr. Decker. Decker hits her with this with AR-21, and there's a 20%, 10 to 20% chance of some residual. But the problem is that with Mavis, it affected her for a considerable period of time. She had 20, 25. I'll let her, and I'll tell you a little bit more about her in a minute. But she missed a number of sessions of performing to audiences for a considerable amount of money because she developed numbness. And the way I see the theory of the case is that she wasn't informed anything about the potential for numbness. She develops the numbness after the injection. She goes back and sees Decker. Decker works her into a schedule, spends about 30 seconds with her, according to Mavis, 30, 45 seconds. Says, gee, it'll go away. You just have to wait for it to wear off. And in the meantime, this lady's losing income. And that's the case in a nutshell. And several features about this. When I got referred the case and looked at it on the pleadings, I agree. I think that there's potential problems. And then I met Mavis, and she's one of the best clients I've ever had. She makes a tremendous appearance. And in a good faith effort to get this thing resolved, potentially today, I brought her. And I want you to meet her. She's very credible, and jury's going to like her.
I'll be glad to meet her, Jim, and I'm glad you brought her. That will be helpful for me to get acquainted with her. But let me say a couple of things before you invite her in. First, I'm really pleased that you decided to drop the punitive damage aspect of this case. And I realize this petition was filed and prepared by a lawyer before the matter was referred to you, but certainly that lawyer did not know anything about the current Missouri law on punitive damages. As you know, there's no possible punitive damage in a claim like this.
I agree.
And that's half of the amount that's prayed for here, $1 million, which on its face is ridiculous, and half of that, of course, is punitive damages, and I'm glad to hear you agree that cannot be allowed.
That's out. I agree.
With regard to the claim of negligent treatment, although I haven't studied the medical literature, you mentioned that it's not proper to have used this medication on the very first visit because it is more appropriate for a chronic, long-standing condition. But I did note in the medical literature that it is prescribed often for acute, sudden onset conditions. And I believe that's the kind of condition your client described to Dr. Decker. So perhaps we can argue about that, but It does seem to me that at least under some situation presented by your client, that would have been the proper use. It really seems to me, Jim, that the primary issue in this case is probably that of informed consent and whether or not your client understood that there was some risk to the use of this drug. And indeed, there is some risk. The PDR describes some of the complications that can occur. Are you able to give me any parameters of what your expectation is in the case?
Yeah, I do. And let me go back to one thing. I agree that, as with any medication, there's some potential sequelae, untoward results. But in this instance, with Mavis, what makes this a more attractive case than when I first saw it on the pleadings, this lady's a jazz pianist. She does this for a living with her hands. Dr. Decker never inquired as to what her profession was, and I think the informed consent goes hand in hand with unnecessary treatment because instead of giving her any conservative therapy to start out with, any type of hydrotherapy or anything else, started right out with an injection that carries a known risk to it of numbness. Never told Mavis about the potential of numbness, and I think that's the problem. Now, she missed a number of engagements, and I think I saw from interrogatories that's about 60,000. She had 20 visits for therapy afterwards, and I suppose arguable whether or not they were all necessary. I brought the record so you can look through those if you haven't seen them, because I know you're new to the case. And then, of course, we got the problem that for some reason Dr. Decker decided to go bare. and doesn't have insurance. She is a board qualified, certified. I think she's board certified. We looked her up. So she's got a pretty handsome income, you know, I think the case is worth somewhere around $175,000–200,000. You take the specials, you take the fact that the lady not only lost, Mavis lost not only the performance money, but she lost the goodwill that goes with that, and the audiences and the people that pick up on that. For jazz pianists to rise to the level that she did, people in the industry will tell you it's very unusual, particularly at her young age. She's a very impressive lady. Case is worth. I don't have authority from her right now, but just looking at it right now, I would think and would recommend to her somewhere around $200,000.
Jim, you mentioned the point that your client is a jazz pianist, and her hands are particularly important to her, and of course that's obviously true. I thought it was very unusual that when your client came to see Dr. Decker, she apparently did not tell Dr. Decker that that was the case, that she was a jazz pianist and her hands were very important. I thought that was unusual. But in any event, with regard to the matter of the treatment, it seems to me that what your client did say, that she had an acute onset of this problem and that she wanted immediate attention to that. And I believe that's exactly what Dr. Decker did. It is true, as we've discussed on the phone, that Dr. Decker does not have professional liability insurance. But for the purposes of our present evaluation, it seems to me that we have to contemplate that Dr. Decker will have to pay this personally. Now, you've outlined for me damages which you think would justify a total settlement of $175,000 or $200,000. I find that extreme. Jim, she had medical treatments for her condition of $20,000. Now that's for 20 treatments. She somehow got in the hands of a therapist that was charging her $1,000 for every visit. Now I know that perhaps we just have to face that fact that that's what she was charged, and presumably she paid it. But I think you'll agree with me that that's a very high, almost unreasonable figure for the medical damages.
There's no question. But here's the problem you got. You got a lady that's supposed to be riding the circuit, playing the jazz piano. She's desperate. She's trying to get this resolved. She sees every one of these engagements goes down, sees future bookings perhaps being jeopardized. She wanted to get resolved. She went to this therapist. No question, $1,000 a shot is very expensive. I brought the records, though. I've looked at the x-rays. She had very minimal arthritis.
Well,
very minimal
Let's just
arthritis.
for the moment accept the medical special damages of $20,000. And even if we give full value to that, and even if we give full value to her lost income, she has actual damages, Jim, of $80,000. And in view of the highly doubtful liability in this case, reasonable settlement would be to just say that the liability is doubtful. We'll just consider it a 50-50 shot on liability, and a reasonable settlement of the case would be in the not to exceed $40,000, half of her actual damages. And that's what I would think that I'd be willing to consider that she should think about.
Well, sorry, we're miles apart.
We sure are.
I think what's going to be important here is credibility of the witnesses. And what I'd like to do, I did bring Mavis with me, have an opportunity to meet her. And then I'll talk to her about, am I assuming the 40's an offer?
No, I don't have any authority from my client to talk about any figure. I don't have authority to make any offer at all because my client thinks that she performed proper medical care, and she does not believe it's a case of liability, Jim. I'll have to talk her into a settlement, a case.
All right.
One's to be made.
Let me get Mavis. Let me bring her in, introduce you to her, and let her tell you about not only the first visit, but a little bit about the second visit, because I think that's got a lot of jury appeal to it.
This was mainly an adversarial negotiation dealing with the amount of the settlement. Each lawyer made sure to stake out a clear position and to defend his position by showing the strengths of his case and emphasizing the weaknesses of his opponent's case. The lawyers focused principally on what would happen in court. In what some may label posturing, the lawyers have set the settlement range at between $40,000 and $175,000. In the following segments, the clients join the negotiation. The group continues the adversarial negotiation and begins to also engage in problem solving by increasing the number of issues for consideration. This segment also shows some advantages and disadvantages of including clients in settlement negotiations.
Larry, this is Mavis Thompson.
How do you do, Ms. Thompson?
How are you?
I certainly appreciate your willingness to come here.
Mavis, as I told you, Larry is relatively new to the case. An associate in the office has been handling it, but he has now taken over for that associate in representing Dr. Decker. And I want him to meet you. I want you to be able to be free to tell him, and want you to tell him about the 2 visits you had with his client, Dr. Decker. Would you do that for us?
Sure, no problem. The very first visit, I think, may have lasted approximately, just initially when she was explaining to me about the procedure, it couldn't have been over 5 or 10 minutes. And the whole visit, I would say, lasted about an hour, just the first time.
And she never told you anything about potential for numbness?
No, sir, not at all.
And then tell him about the second visit after this tingling. I think you told me the tingling started about 12 hours afterwards, and then within a day and a half, you were getting numb.
Within 36 hours, I was totally numb. My right hand was totally numb. I immediately called the doctor's office, scheduled an emergency appointment, went in. First of all, I waited for 1 hour before anybody came out to see me. Anyone. Then, when they did come out, they said, you have to take more x-rays. Now I'm going through more therapy, more x-rays. Then about a half an hour after the x-rays, they have me sitting in the exam room. Very uncomfortable. I'm there in the exam room, on the exam table. Doctor comes bustling in. She's not even paying any attention to what I'm saying. I said, Doctor, what happened? My hand's still numb. Oh, don't worry about it, she says. It's only a normal wrist procedure. She walks out. 40 seconds at the most.
And that's what she left you with?
40 seconds at the most. Oh, normal procedure, she says.
So, Larry, I mean, as I told you earlier when we met before Mavis came in, you got a situation where you got a jazz pianist, makes her living with her hands. Dr. Decker gives her the injection, never once tells her anything about the potential for numbness, because Mavis will tell you now, and she'll tell you in front of the jury, if she'd known that, she would not have undergone that shot. She would not have done it with that risk. Even the risk is only 10 to 15%. To her, it's 100% of losing this business if it happens to her. She goes back and sees Dr. Decker, and Decker dismisses her with a, gee, it's part of what you got to expect. Wait on it, it might improve. That's unconscionable.
Do you mind if I ask Ms. Thompson a question or two that might help me understand the situation better, Jim?
Okay.
Ms. Thompson, I know that you visited with another lawyer before Mr. Bartimus took over this case.
Yes, I did.
Now, I've been furnished with a statement of undisputed facts in the case that's been signed by you and signed by my client, Dr. Decker. And in that statement of facts, it says that it's been agreed upon in the case that you were told prior to the treatment that you might have some numbness. And do you recall signing that statement and being told that by Dr. Decker that you might have some numbness following the injection?
Well, didn't she tell you that was, for your instance, highly unlikely, and that with more chronic conditions?
Well, I accept that. Maybe it was unlikely.
Yes, yes, sir. She did tell me that there would be some numbness, but I mean that
was an
just
unlikely
situation. Sure,
I
that was just like a normal risk of this type of treatment. But she assured me that the treatment would relieve my problem.
Of course, and you needed to have that cleared up because it was you were afraid it would affect your ability to play.
Exactly.
I'm sure, and you wanted something done right away. If
exactly.
possible.
But now, Mavis, weren't you still, even though you had the pain in your hand, you were still able to play at that time?
Oh, no, at that particular time I was still able to play.
Right.
But the 2 days after the injection, I wasn't able to play since then.
We're not going to claim future damages as a result of the injection.
I appreciate that.
I don't know, the petition probably wasn't clear. But what we are going to claim is that the lady was out 8 weeks, all the performances that she missed. How many? 24, Mavis?
24 performances, but the most important performance was the children's home engagement, which is, I do this every year. The children really depend on me, and I get a lot of goodwill just from that particular performance. And I was unable to do that this year, and I think out of all the you know, the paying performances, yes, they were approximately 24. But the one to the children's home is the one that I really missed the most.
Ms. Thompson, over there at the children's home, have you ever noticed that Dr. Decker was there providing free clinic services to the children there? That's something that she often did.
No, I never knew Dr. Decker.
I didn't know.
Dr. Decker gave free services?
Yes, that's right. You find that a little incredulous.
Yes, I do.
Well, it seems to me, Ms. Thompson, I don't mean this out of any disrespect, but it would seem to me that a large part of your feeling in this matter is you're just plain mad at Dr. Decker. Is that right?
Well, yes, I am quite angry with Dr. Decker. The second visit really sent me to the ceiling. She came in, she bustled in. It couldn't have been 40 seconds total. She wasn't even listening to what I was saying. It was like she was totally preoccupied with something else.
Did you know that the reason she bustled out was because she got an emergency phone call, and as soon as she took care of that, she came back in to give you further attention, and you were gone?
Doctor, just excuse me, I'm calling you a doctor now, but just a mere explanation. I'm sorry, Miss Thompson, I have an emergency going on. She didn't do any of that. She came in totally preoccupied. Sure. Another thing that I have to say about that, if Dr. Decker is such a caring person, why isn't she here today to talk to me in person?
You know, Jim, there does seem to be a misunderstanding of what happened during that second visit, and I understood from Dr. Decker that she had an emergency situation that she had to take care of, and as soon as she came back, you were gone. Apparently you'd left in a huff. Maybe you didn't understand.
Well, why isn't she here now to explain?
Well, I think it might help if that was explained.
I think we ought to get her.
All right. I told her to stand by in case we needed her, and I'll be happy.
That would be appreciated. Yes.
I think it'd be helpful.
She'll be
Let's
very,
bring her in and see if we can.
She'll be very pleased. She'll be very pleased to come over, and I'll leave now and make the phone call and ask her to come over.
Good.
Jim, I've asked Dr. Miriam Decker to come and meet with us. She's here at the conference table now. This is Mr. Jim Bartimus.
Hi, Doctor.
How do you do, Doctor?
And I
Mr. Bartimus.
Nice to see you.
appreciated your suggestion very much that Dr. Decker come over, because I had previously talked to her about this meeting, and she had asked me if she could be present to explain what had happened so that there would be no misunderstanding. And I responded to her that that was fairly unusual for clients to be present when lawyers attempted to negotiate a settlement of the case, but she said that she would be pleased to stand by and be available. And I think now, since there does seem to be some misunderstanding or confusion about perhaps what actually happened when your client was in my client's medical office, I think perhaps it might be a good thing for Dr. Decker to explain at least part of that. Do you have any objection to her doing that?
I don't. I think it's good. Doctor, I'm glad to see you here.
Dr. Decker, could I ask you to please explain to Mr. Bartimus and to Miss Thompson what it was that prevented you from having a full discussion with Miss Thompson when she came back to your office with the complication of the treatment that had apparently she developed in her hand. You were aware that she'd had a complication of your treatment, were you not?
Yes, I was aware of that.
And were you able to make a full explanation to her about that when she was in your office on that occasion?
No, on that particular occasion, it was a very busy day, I remember. I had an emergency at the hospital. It was a packed office day. We had squeezed her in basically to a slot that I really didn't have, but she called and complained about this problem, and I thought it was important to see her and try to take care of it. When she came in, the staff had informed me that she was very angry, and I was very willing to go in and talk with her about this. But right as I got into the room, I got an emergency phone call from this patient at the hospital that I knew was there. I had to go out and take the call, and when I got back, she was gone. She just up and left and did not give me a chance to make an explanation, and I feel very... I don't even know how to describe it. Like I never had a chance to even give her the treatment or response that she was looking for.
But see, Doctor, why would...
Excuse me, Miss Thompson. I don't mean to interrupt, and I know you'll have some questions for Dr. Decker.
I sure do.
And I want you to ask those questions, but I would like to just ask you to, Dr. Decker, just one more item. On the first visit, when Miss Thompson came in with her problem, and you don't need to tell us all the details, but I'd just like to know if the treatment you gave her on that occasion, was it in accordance with standard orthopedic, hand orthopedic standards?
Yes, I did a postgraduate fellowship at Stanford University, and this was a very up-and-coming, most appropriate treatment for her kind of problem. It's very state-of-the-art. I was trained in this technique, and I thought it was the most appropriate treatment given her pain and symptoms that she described to me in her hand and the problems that she was experiencing.
All right.
Doctor, you went to school at Stanford out in California?
Yes, that's where I did my postgraduate fellowship.
And this is the kind of treatment they give out in California?
This is the kind of treatment that is the most state-of-the-art treatment across the country, not just in Stanford. Stanford is the place that developed the technique, and it's the place to learn how to do it.
All right. Well, I do want to ask you a couple things about that since Larry opened that up. But I don't want to take away from Mavis right now because I know you've got a couple questions working backwards about that second visit. Let's start with the second visit.
With the second visit, doctor, now it comes to light that you had an emergency. I can understand emergencies come up, but no one explained that to me, doctor. You could have easily had one of your nurses or the receptionist come out. Initially, I waited an hour there in the waiting room before anyone even came out to see me.
Well,
and then
we
made
never
me go
like to
through
have
more
people wait.
x-rays. Why the extra x-rays?
Because I felt it was important to know how your hand had progressed from the first time I had seen you. That's very important to my care. If they didn't explain to you my emergency situation, then I apologize because my staff should have done that, and I'm sorry. But I also feel that you just shouldn't have gotten up and walked out of the office and not given me a chance to come in and examine you.
But doctor, surely you can understand. I understand perfectly today. I'm glad that we got that part settled. Because, yes, that was a great deal of the reason why I was angry that day. I waited for an hour. When you finally came in to see me, you acted preoccupied. Now I know that there were emergency situations, but all I wanted was a simple explanation of why I still had this numbness in my hand and what you could do to resolve that.
And I was perfectly willing to give you that explanation and to follow up with your care and provide you whatever assistance that you felt you needed. You never gave me the opportunity.
Well, I appreciate that you are explaining now about the emergency. That does make a big deal of difference.
You indicated that on the first visit she said she wanted to have her hand taken care of.
Yes, sir.
And you knew, and she told you that she was having some, what might be described, and I saw in your medical record, some type of early onset of arthritic condition. And I think you know, as well as I do, that AR-21 is a drug used by less than 10% of your profession. It's used in those instances where you've got active rheumatoid arthritis, where you've got debilitating degenerative joint disease. And I've looked at those x-rays, and there's no debilitative joint disease on those x-rays. There is a little arthritic spurring on the metacarpals, but you gave this lady no choice, as I understand it, and you correct me if I'm wrong, of any conservative treatment. And I'm assuming you didn't because you didn't ask her what her profession was. You didn't know she was a concert pianist, a jazz pianist. You give her this shot, and she ends up with the sequelae that is indicated in the PDR.
Well, I think you're making a lot of assumptions that just aren't
Well,
true.
that's what I want to know.
First of all, yes, only less or 10 or less % of my profession does use this drug because they're not qualified to use this drug. You need training, and if you don't take that training, you're only asking for trouble if you're using it and you don't have that training, and I have that kind of training.
Now, the training relates to the actual injection itself?
The injection, knowing the appropriate circumstances to use the drug, knowing what kind of side effects will follow, the follow-up care after the injection, yes, the whole ball of wax of treatment using AR-21. I think that's a very specialized type of treatment.
Okay.
And you need to be a specialized person to give that treatment, which I am qualified to do. I think your second point was that she didn't have the right kind of conditions, and I would say that that isn't true. It can be used in acute conditions. It can be used in the type of symptoms, with the type of symptoms, and with the x-ray pictures that I saw of Ms. Thompson, she was very adamant in getting this treatment, in getting this kind of treatment and in getting her problem solved.
Well, I know
the third thing I think you assumed was that I did not discuss with her the other possible forms of treatment, and that isn't true either.
Not in your record.
We discussed those forms of treatment. Yes, it may not be in my record because I am a very busy surgeon and I want to care for my patients. I do what I think needs to be done for the patient. It doesn't always get in the record. That's my fault because I know I should document better. My lawyer tells me that all the time, that I don't document in my records the way I should.
As well as you should. I think a jury might tell you that too.
But I'm more concerned with caring for my patients that are coming in to see me.
All right. You know Dr. Waller over at the university.
Yes, I do.
And you know, and I think Larry now knows that I've consulted with Dr. Waller about this case, about AR-21, which he has elected not to use in this area. I realize you might do that out in California, but it doesn't seem like that's a standard of care here. Irrespective of that, one of the things that seems to be important here is that there are clients or patients, I guess you folks in the medical profession call them, who might require AR-21. But this lady, you exposed her to her livelihood. This isn't a situation where she does some type of administrative work where she could get by perhaps with less hand movement. This lady's a jazz pianist. And it doesn't
She
seem
never
like...
once told me that.
But doctor...
But doctor, you never asked about my profession. And anyway, to me, I didn't see that it made that much of a difference. I came in with an acute problem, and I needed to have that problem solved fairly quickly. And you only told me that there would be slight numbness. 3 days later, I couldn't even move my hand. I couldn't even feel anything in my hand. I had to go through at least 20 additional therapy sessions just to try to correct the problem that I originally came to you, and that's why I was so upset.
My standard practice to explain thoroughly the side effects of any medication or treatment that I would give. You were very anxious to get this treated. I remember that you were so anxious to get this treated that you barely listened to what I had to say. As soon as I said, I have a possible treatment, and here, these are the side effects, this is what it could do for you, but this is what it might do adversely, you didn't want to hear those things. You just said, oh, let's do the injection. I need my hand to be fixed. You never told me why. You just were adamant about having this fixed.
Okay. Let me cut this off for just a second.
You never told me that it was so important to use your hands.
Well, ladies, you got a fact problem here that may take a jury to resolve. Mr. McMullen mentioned one thing, doctor, that about the children's home and about voluntary work there. And, of course, Mavis puts on an annual performance there, which you may know about. It's in the papers and very well publicized. Had to miss it this year. What involvement do you have down at the children's home?
One day a week I go down there and volunteer for free care for the children. I have even done surgery free of charge, follow-ups. I'm very involved with that. I think it's very important that these kids get good care, which their parents can't afford and they just don't get.
What's your availability right now? Do you have a little time right now?
Yes, I've cleared my afternoon.
Larry, why don't we, maybe be a good idea right now, let me talk to Mavis about a couple of things. It might be good that you talk to your client because I think that there's some difficulties here. And I think I believe that.
I think we should do that, Jim. But before we break, I think we should all know that you mentioned an outside consultant had looked at this case, a Dr. Waller at the University Hospital, and I think everyone should appreciate that another doctor, Dr. Sullivan at the University Hospital on the other side of the state, has looked at this case, and he has said, Ms. Thompson, that the care provided by my client to you was completely appropriate and within acceptable standards. And I know that there perhaps can be differences in points of view on that, but I wanted you all to know that Dr. Sullivan, who's a prominent surgeon at the University Hospital, has said the care given was completely appropriate. And I'd like for one thing to be apparent, so we're all on the same wavelength before we talk to our clients further about this. I want Ms. Thompson to understand that any settlement that would be made in this case it would not be on the basis that Dr. Decker believed there was any substandard care. You do not think so, do you?
No, sir, not at all. I believe my care was exactly appropriate.
All right. And I think
I would do it again.
Further be recognized that when you talk about the amount of any settlement, that any settlement will be paid, as I've told you, Jim, from Dr. Decker's personal account. She has no professional liability insurance, and she will have to pay this herself. That has a very direct bearing, as you know.
Which would also have a direct adverse effect on my care at the Children's Hospital, at the Children's Home.
I understand your position. I hear what you're saying. And I know what duties I have to my client, so let me discuss this with my client.
I think it would be a good time to do that.
All right, let's do it.
In the last segments, the participation of clients provided a number of potential advantages and disadvantages or risks. One of the potential advantages was that each lawyer could evaluate the opposing client's jury appeal. In addition, each lawyer had a chance to demonstrate his own skill as a lawyer, the credibility of his client, and the strengths of his case. Each client had an opportunity to clear up misconceptions, and the clients also had a chance to talk directly with one another, which may itself have been beneficial in helping them better understand each other and better understand what actually happened in the case. The client's participation also made it possible to increase the number of issues for discussion, which is a common strategy of problem-solving negotiation. For example, they were able to discuss their mutual interest in the children's home and their frustrations with one another. There were also risks or potential disadvantages in having the clients present. For example, one of the clients might have shown herself to be an unappealing witness or revealed something that was harmful to her case. Neither of these risks materialized in this negotiation. However, for a few moments it did appear that Dr. Decker jeopardized her case by calling the treatment up and coming. But because she was present, she was able to clarify her statement and with her lawyer diffuse an argument by plaintiff's lawyer that this was not an accepted medical practice. Another risk is that the direct exposure of the clients to one another could lead to a hardening of positions. The next step was for the lawyers to meet privately with their clients. Mr. Bartimus learned that his client felt satisfied with Dr. Decker's explanation of her apparent rudeness. He reviewed the strengths and weaknesses of their case, emphasizing that Dr. Decker would have as much jury appeal as Ms. Thompson, and that juries tend to favor doctors. He predicted that if they won, the best possible jury verdict would be in the range of $90,000 to $125,000, and that they had roughly a 50% chance of winning. He recommended that Ms. Thompson give him authority to settle for $60,000, saying he would try for the $80,000 to $90,000 range and would hope to get $75,000. On the defense side, Mr. McMullen learned that his client still felt that Ms. Thompson did not understand her feelings. He suggested that they try further to show Ms. Thompson that Dr. Decker was kind-hearted, and he asked Dr. Decker to tell him her plans for working at the children's home. Then Mr. McMullen reviewed the strengths and weaknesses of the case, concluding that there was a substantial chance of a jury verdict against them. He said there was a remote risk that the verdict would be over $200,000, a reasonable chance that it would approach $150,000, and that the most likely verdict would be about $100,000. He asked for authority to pay $90,000. When the lawyers began the next session, plaintiff's lawyer had authority to accept $60,000, while defendant's lawyer had authority to pay up to $90,000.
Jim, I've been over this at length with Dr. Decker, and I have to tell you, I'm not very optimistic. I pointed out to her, and she heard you say it, that your demand in this case was $175,000 to $200,000, and in any way that she can think and that kind of money. I also have a terrible problem in dealing with her, that she's convinced that the care given was completely appropriate. For all those reasons, I'd be surprised if we get this done. Well, on the other hand, now let me say on the other hand, she's personally at risk in the case. Her personal finances are at risk, and I think if the case could be settled at a certain level, she would do it, even though she's convinced that she gave good care, in order to remove that personal risk. And so, now why beat around the bush? I'll just flat out and tell you. I think that level's $50,000. That's where I think it is. I think that's what I can do.
Well, the problem is, and I appreciate what you're telling me, the 175 was based on the authority that Mavis was adamant about before I ever came in here today. And a lot of that was dealing with a pound of flesh. And I think it was good you brought Dr. Decker in. I think Mavis has now seen that Dr. Decker had other problems, wasn't just ignoring her, and I think that bothered her more than anything. I don't want to bid against myself. You and I talked early on about 40, you're now to 50. That's a small move on your part. But at the same time, I've got a client I think is a little easier to work with and a little more understanding. I'm convinced that if I got Mavis and sat her down and spent a little more time with her, that would probably be able to get authority from her at 90. And I think 90 is a good figure. It covers her. It covers the 60 she lost, makes her whole for the problem. I realize that there's some debate about the 20, but that's out of pocket. So there's 80, and that gives her 10 on top of that to try to build up a little goodwill with the people that she lost and maybe do a little PR. And 90 is a good figure, and I think our chances of winning are better than 50-50. And of course, Dr. Decker's exposed. She's out there with no coverage. It comes out of her pocket, and we'd execute on her.
Well, there's no sense to argue about it, Jim. That's just not she's going to say 90,000 is like $100,000, and she's not going to listen to that. And she's she's told me that $50,000 is the top amount that she wants to think about, and I don't know any way to try and resolve it, Jim, except maybe we're $40,000 apart, and maybe we can both tell our clients that one way to solve this, if they want to solve it, and I have no idea whether she'll be interested in this or not. It might be to just split that and try and get them each to think of a settlement at $70,000. I don't know any other way to resolve it.
Well, I don't either, and it's fish or cut bait time because we're on a trial docket, and Mavis has got she's just got a few minutes here because she's got to leave for a trip. Larry, why don't you make her whole? Why don't you? I think that again, I don't want to bid against myself, but at the same time, Mavis is a very sensible lady. I can reduce my fee. Why don't we make her whole? Give her 80, and I think if you made a suggestion about Dr. Decker, you mentioned she said something early on about going down to this clinic, and I think that helped. I think Mavis sees that she's a little more humanistic about that now, and I think that's important that she understands she's just not a money machine. She's got some interest in that regard, and I thought that was important to know that. So maybe she'd do it at 80.
Well, let's see. You say you'd be willing to recommend 80. I think what I've said is I'd be willing to recommend 70, although I have no idea that I'd find any acceptance at all. And I like your suggestion of maybe getting something else into this besides just the money that will make these two clients of ours feel better about each other.
What?
Well, I think I would suggest to Dr. Decker that she perhaps increase her free activity at the children's home. That's a place that your client's very much interested in.
Very much so.
She goes there and performs.
What would she do?
Well, I think she could, we'll ask her about this. She may have an idea, but some form of regular activity that demonstrates to your client that she's truly interested in people and not just in money. We couldn't put this in the settlement documents, you understand, but I think if our two clients come to trust each other a little bit, and maybe
right,
that would work.
I think that'd be just about as important to Mavis as being made whole financially.
Then maybe if I can also say that you and I had a very difficult time negotiating this case, and at the end we were both willing to be fair and to give way on our demands equally, and that means if you're at 80 and I'm at 70, we ought to recommend $75,000. I don't have any idea if either one of our clients will go for that.
Mavis had to pay some of that out of her pocket. Make it $77,500, and I'd tell her to take it.
You'll tell her that she should take that?
Tell her
if I can get my client to pay it.
If you and with the agreement that your client does what she said she's going to do, and that would be go down to the clinic, and she could explain that to Mavis because I want Mavis to hear that herself. I'd tell her to take $77,500, and that'd be the end of it.
All right, on the commitment that you'll tell her that she should do that, I'll make that recommendation.
All right, let's get him in here. I think it's important that Mavis hear Dr. Not just coming from the lawyers. I think she needs to hear it from Dr. Decker that she'll go down to that clinic and that this will be resolved, and it'd probably be good for Mavis to hear it directly from her.
I agree.
After this session, the lawyers met privately with their clients and explained the proposed settlement, and both clients agreed to it. Then the lawyers brought their clients in for a final session in which they all discussed the terms of the agreement. The clients talked about their mutual interest in the children's home. In addition, each showed that she understood the other's perspective, which might have led to an improved relationship. In the last segment we watched, there was an interesting mixture of adversarial and problem-solving techniques. The two most prominent adversarial techniques were attempting to mislead each other as to their authority and splitting the difference between their last two positions. The principal problem-solving technique was to include explicit discussions of two issues that would have been irrelevant in court but were important to the clients and to the settlement of the case. The clients' common interest in the children's home and their feelings about each other. Often there is a tension between adversarial and problem-solving approaches. Each approach has the capacity to interfere with the other. If the lawyers had been extremely adversarial, for example, they might not have opened up discussions of their clients' mutual interests in the children's home or allowed their clients to discuss their feelings toward each other. This would have made problem solving nearly impossible. In addition, a negotiator can use an adversarial approach to take advantage of a negotiator who uses a problem-solving approach. In this case, however, both sides employed both approaches effectively. Using adversarial approaches, both sides staked out their positions with respect to the payment of money and justified these positions with arguments about what would happen in court. Under problem-solving approaches, both sides brought out the client's underlying interests in righting their relationship and in helping the children's home. The parties began to repair their relationship during the negotiation process, and the resulting agreement included both a financial settlement and arrangements that would benefit the children's home. Plainly, both adversarial and problem-solving approaches have a place in the lawyer's repertoire. A negotiator must consider when and how to use each of these approaches and the related question of when and how to include a client in a negotiating session. Lawyers who use hard and fast rules to answer these questions will miss many settlement opportunities. The important thing is to consider the precise circumstances of each case and the needs and personalities of the people involved.